Welcome to Family Law Unfiltered with Emily.
Hi, it's me again. You're watching Family Law Unfiltered with your host, Emily Marx. Today we'll be talking about child support, California guideline calculations, and income nuances. California child support is calculated using a complex statewide guideline formula, primarily based on parental income and timeshare with the children. And this is outlined in California Family Code Section 4055. We as attorneys use software to calculate guideline child support because there are dozens of variables and factors that go into it. Income is the most critical factor. The court considers each parent's net disposable income, which is gross income minus certain approved deductions. These include taxes, mandatory union dues, health insurance premiums, child support payments for children out from another relationship, and there are a few others. Another consideration, major consideration in guideline calculation is timeshare. And that is the percentage of time each parent has physical custody of the children, and this directly impacts the support amount. I usually calculate by hours. There are 8,760 hours in a year. And so knowing that, I calculate the hours with the client I represent, and I determine timeshare that way. The more time a parent has, the lower their support obligation, or the higher the support they receive if they're the recipient. Let's talk about income available for support under the Family Code versus income deductible for tax purposes. There are several overlapping deductions, but they're not identical. Income available for support under family law, income available for support in California under the Family Code begins with the gross income of the parent. That includes whether the parent is the paying parent is, the calculation includes information for both. But we start with the gross income, and that can be via a W-2 or gets more complicated when the parent is self-employed. We'll talk about that. For child support, gross income is broadly defined and includes many sources. This includes disability benefits, workers' compensation, and some untaxed portion of pensions. While tax deductions reduce taxable income, only specific deductions are allowed for child support purposes. And again, some overlap. Discretionary deductions, like 401k contributions beyond mandatory limits, are not deducted from income for support calculations, but are deducted for income income for taxable purposes. So that's an example. But the flip side, some non-deductible expenses, according to the IRS, are deductible for income from income available for support. So where a business owner might claim that some profits must be recapitalized or are otherwise necessary for operation of the business, those expenses can be deducted and are deductible from income available for support. And sometimes a forensic accountant is necessary, but not always. A detailed profit and loss ledger and an experienced attorney can determine what a self-employed person's gross income for support is. If the court finds that one parent is unemployed or underemployed, they can calculate support based on what that parent could or was earning, rather than what they are actually earning. This is typically done where a parent is underemployed by choice or unemployed by choice. And it is unfair because under the California Family Code, both parents have equal obligations to support their minor children. This can also become an issue with self-employed payers who might manipulate their reported income, but we talked about that. A detailed profit and loss statement and or a forensic accountant can determine cash flow, and they can determine what expenses may be, at least arguably are, necessary for operation of that business and therefore deductible. Forensic accountants uncover hidden income by scrutinizing business financial records, analyzing bank accounts, reviewing tax returns, investigating lifestyle, and identifying perks or add backs. And those are personal expenses paid by the business that are added back to income for support purposes, but are not necessarily taxable. However, forensic accountants are not always necessary, like I said. As an attorney, I'm fully capable, and actually I enjoy reviewing the profit and loss statements and determining for myself and for my client what the income available for support actually is. And again, we start with that gross number. Another tool, the court may order a vocational evaluation for an underemployed parent, and that happens in spousal support cases too. Where the court can order a parent to undergo a vocational evaluation by an expert and determine what that parent is capable of earning in the market. And that vocational evaluator is an expert, and they will testify if needed. And the court typically does, use the testimony and the figures that the vocational evaluator came up with. Or something close to it. They can deviate a little bit here and there, but it is powerful evidence. They are expensive, and oftentimes the court will order the person asking for it to pay for it, subject to reallocation depending on the findings. Once that vocational once the findings of that vocational evaluation are in evidence, again, the court can impute that income to a parent. That is less likely to happen in child support cases, I think, for obvious reasons, because the child's needs are paramount, but it is very common in spousal support cases. Child support judges can order it also, though, the vocational evaluation. Recent changes to California law have affected the allocation of child support add-ons. Previously, allocation of child support add-ons, and that includes mandatory add-ons. Those include costs for daycare or childcare so that one parent can get job training or work, and the other is for out-of-pocket health expenses. Those are the two mandatory add-ons. Discretionary add-ons include extracurricular activities for the minor child, and they also include travel expenses for visitation. I also bring up, as an attorney, I argue this discretionary add-on often where the parents live in separate states and therefore incur significant costs to visit with the minor child or children. So previously, the add-ons were split 50-50 regardless of income. However, now the statutory requirement is to allocate all add-ons, mandatory and discretionary, in proportion to the parent's respective net disposable incomes, unless there's a specific reason not to. When we're talking about that net disposable income, that is calculated by software that we attorneys use. It's not some magic number, but it's also not something that you can calculate on your own unless you're an expert accountant or a forensic accountant. So we rely on the various software applications to calculate guideline child support, and then which necessarily calculates the net disposable income of each parent. Regarding dependency exemptions, IRS controls this. Dependency exemptions are controlled by IRS law, and the parent with a higher timeshare is entitled to take the dependency exemption. However, sometimes it is beneficial to both parents for the child support payor or the higher earning parent without custody to claim the exemption, especially when the receiving parent is unemployed because they don't file taxes. So parents can agree to alternate or give away the exemption for the other parent, and this can be formalized in a court order and by executing IRS Form 8332, which requires both parents to sign and acknowledge the transfer of the dependency exemption. So that is, I use that in my practice sometimes where the calculations reveal that both parents would benefit financially from alternating or from giving the exemption to the parent with less timeshare. Finally, do not stop paying child support if you lose your job. This is a common question that comes up. I lost my job, I can't pay it anymore. Do not stop paying it. Immediately file a request to modify the child support order. That modification, that request, will initiate the start date whereby which the court will be able to modify. So if you file your request August 1st, you don't have a hearing till October 1st, the court has jurisdiction to modify your child support as of August 1st. That doesn't mean you should stop paying it. You shouldn't, or at least pay what you can. But you will be entitled to a return or refund of those funds. A lot of times attorneys will contact DCSS and ask them to freeze any amounts that are paid after the modification is filed. But know that the immediacy is what's required, because the court does have jurisdiction to modify back to the filing date and not just the date of the hearing or the service date like in other examples. So note that California Family Code Section 3651 allows for modification of your support obligations based on a material change of circumstances, but modifications take effect from the date you file and not the date your income changed. Meanwhile, if you do not pay support without a court order and your modification is unsuccessful or not what you anticipated, you will accrue arrears, which are past due support payments and are subject to a 10% compound annual interest. They are aggressively enforced by the Department of Child Support Services and the other parent, and they can pursue various enforcement actions. This can't even be stopped by the other parent. The other parent who's receiving DCSS services cannot order or ask DCSS to stop enforcement. They will do it anyway, even if the other parent doesn't want them to. So they can be and are a very powerful agency. And you do not want to go into arrears when Department of Child Support Services is enforcing child support in your case, because they will garnish your wages. They will levy your bank accounts. They will suspend your driver's license. They will suspend business licenses. They will deny passport renewal. There are various other enforcement remedies. Oh, they will refund tax. They will intercept tax refunds. And so that is something that you never want to get involved in. A lot of my clients in the past have low principal balances and really high interest balances. It's kind of sad to see. One last thing I'd like to talk about is the jurisdiction between family court and DCSS, very briefly. If DCSS, Department of Child Support Services, is involved in your case, most family court judges will avoid making orders, and they will refer you to Department of Child Support Services, which has two departments, L51 and L54, located at Lamoureux Justice Center. And those are just for Department of Child Support Services cases. The exception might be when the family court initiated the child support order that is then being enforced by Department of Child Support Services. In that case, a family court may be willing to modify or look at the child support orders, so long as Department of Child Support Services is noticed of the hearing. And that's about it for very briefly, that's about it for child support modifications and otherwise in California. If you have any questions, please post them in the comments and I'll do my best to answer them. Thank you for watching. Our next episode will cover domestic violence. We'll focus heavily on defense of false allegations and talk a little bit about prosecuting domestic violence too in the civil arena. Thank you again for watching, and I hope to see you again.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.